Hello, everyone. Warm welcome to this workshop on EU pro bono in EU strategic litigation, the Coman case. For me, this is continuing the celebration of the judgment and of the case for many reasons. Firstly, because it was a very strong, it was a landmark judgment clarifying EU law, clarifying the term spouse in Freedom of Movement Directive. And secondly, as a big fan of strategic litigation, for me this is a very nice example of how the case came about, how it was argued, the campaigning strategies that were employed to support the case, and most importantly, the collaboration that was built and actually contributed to the success of the case. So for many, many reasons, this is a great case to continue celebrating and discussing. And I'm very pleased to have the incredible speakers, with their impressive experience, to share how they did this and how we reached to this landmark judgment. So they'll tell more about the case. We have Justina Ionescu from Romania. She's a human rights lawyer working with Accept Association. Justina has worked on other cases to European Court of Justice and European Court of Human Rights. So welcome, Justina. And then we have Jacqueline McLennan from White & Case. Jacqueline is partner in White & Case, and she's leading the pro bono team at White & Case, but also the team that worked very closely with Justina and Romanita, another lawyer in the team, especially in the time leading to the hearing at the Court of Justice, which was incredibly difficult time. So welcome both of you. Before we start, I just wanted to ask how many of you know about the case or have heard about this case before? Thank you. Considering that we have quite a short time to discuss this case, I would suggest if you have any questions in mind, welcome to address them now, or if there's anything in particular that you would be interested to hear in this short period of time, you can give us a shout now, or of course, in the end we'll have question-answer time, and you're welcome to raise those later on as well. Okay, I think we can then proceed to hearing more about the case. And Jackie, so what, as an expert in EU law, I wanted to ask you to to tell us what was the gap that this case tried to address in EU law, and
why it was so important.
What was so important?
Arpi just described it as a landmark case, and I can't think of another way to put it. However, it's a step, albeit a seminal step, in a journey towards the full recognition of the rights of same-sex couples to marry in Europe. Now, this is a situation where I have to say, as a citizen of the EU, I'm quite astounded that Europe is, or EU law is behind the US here. Because we're not quite at the stage that's been achieved by the Supreme Court in Obergefell. But what this case did was say that, and I'll try and make this simple, that if you are a same-sex couple and you get married in one member state, Belgium, or any of the other 14 member states out of the 28 member states in the EU, which allows same-sex marriage, then you have a right to go to any other member state with your spouse and have full residence rights and accompanying rights there. And the gap that the case has filled is exemplified by the Coman case, which was that if you got married in Belgium and you chose to go to Romania, there was absolutely no right to go there with your spouse. And Romania indeed confirmed when Adrian Coman applied that he was not able to take his spouse with him because Romania does not allow same-sex marriage. So there's still a gap, if you will, at EU level in that there is no right under EU law or any other law to establish that same-sex couples must be able to marry. And in EU law, there is still the competence of member states to maintain their own law on how you constitute marriage. But now the journey, as I say, has been proceeded along in a very important way, and the gap, in one sense, has been filled. And I think it's a really interesting case because it's kind of excuse me. It's kind of a kind of classic example of what we've been talking about over the last couple of days here at PILnet, which is, can lawyers look outside the toolbox of the classic human rights lawyer and use other forms of law to achieve change? And this case did exactly that, because rather than being a classic human rights case which goes to the European Court of Human Rights in Strasbourg, what happened was that Accept used EU law, used Romanian law, to challenge the fact that Adrian and Clay were not allowed to move to Romania. And then there was a reference made to Luxembourg. Now, EU law is very different to European human rights law, which is achieved through the convention. And I can talk about that in more detail if you like.
Thanks, Jackie. So, Justina, how did this case start in Romania? Why did Accept decide to support the case, take on the case, and what was the situation of LGBTI people in Romania at the time when you started? What was the context when you were working on it?
Yeah, thank you very much. And it's important maybe to give a little bit of context to understand how this case started and the idea of using EU law. It's very much connected to the legal advocacy that Accept has been doing since 1996 when the organization started. At the time, in 1996, same-sex relationships between consenting adults were criminalized in Romania, and this was decriminalized only in 2001. And in 2000, Romania adopted an anti-discrimination law, including the ground of sexual orientation. So that was picture of the legal, the legislation framework in Romania when we had the case. And in the same time, since 2001 up until EU accession, there had been no much advancement in the protection of LGBTI rights in Romania. And all the time when we were trying to advocate for the rights of LGBT people or other human rights issues in Romania, using EU law arguments, the fact that Romania should comply with EU standards because Romania was in the process of acceding to the European Union, was a very strong argument in our legal advocacy. After 2007, when Romania finally joined the EU, the legislators, the government became a bit lazy. Once we were there, they were no longer active in promoting human rights, and in the area of providing legal protection for gay families, there was nothing, and there is still no legislation, no law in Romania. Similar to 5 other EU member states at this moment. So we were, in the same time, being gay in Romania and having a family, a gay family, is very much stigmatized. And there aren't so many people wanting to share their life story, to come publicly and speak about their rights violations, or to even file a case in court to defend their rights. So this was also a challenge in our work. So putting these things together, once we've heard about the story of Adrian and Clay, Adrian is a close friend of ours because he had been director of Accept back in the 2000 when the decriminalization happened. We realized that we have there opportunities. We have EU law arguments, EU obligations, the obligations that Romania has towards EU, and we have a story, a life story of a family that we can use and put forward in relation with the government. So we filed a case against the immigration authorities who refused Adrian's permit right for the period of more than 3 months. And during the hearings, the government has always put forward the provisions from our civil code that say that it is forbidden to recognize a same-sex marriage concluded abroad. Also in Romania, it's forbidden to perform a marriage between same-sex persons. So during the procedure, we started with the case as a freedom of movement case. It involved the directive regarding freedom of movement of EU citizens. But in the same time, there was this constitutionality aspect, and decided to raise also a challenge of constitutionality, and the case reached the Constitutional Court of Romania as the first stage before going forward to the court in Luxembourg. And I can talk more about
I think it's very interesting, yeah, because you had in the heart, when you started the case, you wanted basically to reach the European Court of Justice to clarify the term spouse and to develop the law. But how did you manage to get there? Was there anything in particular that maybe a know-how you could share?
We had a little bit of know-how and luck because we represented a different case at the EU court, Asociația Accept case. 3 years before, in 2013, came a judgment in the field of discrimination in employment on the ground of sexual orientation. So we were familiar with the procedures, referrals, but we needed the judge to refer, the national judge who was hearing the case, to refer the case to the court in Luxembourg. So by the fact of bringing the case to the Constitutional Court of Romania, we managed to raise the importance of the case, to become a quite high-profile case, because that was the first time that our Constitutional Court was hearing a case regarding a same-sex family and regarding the right to private and family life of LGBT people. And at the first hearing, we did not raise the referral because we knew that the Constitutional Court in Romania has never referred the case to Luxembourg. Also that in Eastern Europe, constitutional courts do not make such a referral because they are a bit reluctant in relation of constitutionality and EU law. So we thought that we should go with our constitution because it was a matter of constitutionality. The civil code was in breach of the right to family life in our constitution. This was our argument. But we saw that after that first hearing that went quite well, We also managed to bring a lot of public attention from the Romanian mass media to the case, and I can share more about how we did that. We saw that the court is organizing another hearing, a second hearing, which is not usually happening in cases in front of our constitutional court. So we realized that the court is really not coming to an agreement, and it needs some support in order to get to a decision in our case, which we think it's an opportunity. And in collaboration with our partners, with ILGA Europe and Amnesty International and other international organizations, we realized that it is time to ask for a referral at this second hearing at the Constitutional Court.
Thank you. You mentioned the work with the media, and it was at the time, especially when the hearings were happening, there was another hearing related to the referendum collection of signatures that happened in Romania back then. Over 3 million signatures were collected, if I remember correctly, to change the constitution. So it was happening all in parallel, and I think it was a challenging time to, when you have one case and you work with the media around this case, it's one thing, but when there is a broader hostile context, I think it's different. So how did you manage to still kind of keep going?
So when we start, because these cases, they, at least in Romania, but I suppose in other countries as well, they take a long time. It's about years when you need to be able to put resources into the case, to keep the public attention going with the case, and to keep the beneficiaries, the victims, let's say, involved and still willing to go on and look for justice. And this is an important challenge for us as NGOs, maybe also for the companies, for the lawyers. In our situation, when we started the case, the society in Romania was relatively not so hidden up about LGBT issues, about marriage, equal marriage, etc. But once we reached the Constitutional Court, a few years after, 4 years after we started the case, there was this growing opposition against LGBT rights, against LGBT community, but also against anything that is European or it's imposed from the other countries to Romania in a nationalistic movement. So we were also confronted with a situation where there was the hearing on our case was scheduled on the same day where the Constitutional Court was scheduled on the same day where the Constitutional Court was supposed to give its opinion about the organization of a referendum to restrict the definition of family in the Romanian Constitution to be understood only as marriage between a man and a woman. So we realized, and our communication people worked really hard on this and strategized about this, and realized that we need to talk about the case, Coman case. Up until that moment, we didn't go public so much about the case. And when you do communication, what is important is the starting point. Who is telling first the story of the case? And this is what we managed to control. We told the story first, the way we wanted it to be told, in a very close partnership with the journalists. The national journalists were friendly with us, and we managed to cover all the details that journalists wanted to know about the story. And we did that by also by organizing a press conference before the first hearing at the Constitutional Court, where we had the complainants and their family the mother and father of Adrian Coman was there with them, and the legal team, Accept's legal team was there, available for the journalists to ask any question they wanted to hear, to know about the case. And that was a first thing for Romania, which is a society that is not so much open to this type of issues, and they didn't know anything about gay families before this case, but had the opportunity to see a family that is struggling, a family that is living in different countries and cannot come together, or is limited to come together by the government.
If I can just build a bit on that, and I have to say I'm biased because I and ILGA Europe have been closely following the case for the past 2 years before the judgment came out, and this was an important aspect as well, you know, working with the media and communicating, clarifying what the case was really about. We would get lots of questions, but it's about marriage equality, and you know, EU doesn't have competence and it's not right, or you know, all these questions. And then what Accept did brilliantly, and we worked together, prepared a briefing with timeline of the case, what the arguments were, what the case meant, and what the case was trying to achieve, and it wasn't about marriage equality. I mean, I wish it was, and I wish there was a judgment about that, but yeah, we clarified that it's not. It's about freedom of movement, and it helped greatly, even in the Brussels bubble, to speak properly and to spread the news, the correct news about the case.
For us lawyers, it was also an interesting exercise to be involved in this communication work, which took a lot of energy also from us, because we participated we had to be available for the press conference, for invitations to speak on TV shows, or speak with journalists, and I think it really helped us to be able to talk about the case in a way that all ordinary people understand, not in legalese. And also we saw how important, and we realized how important this case is for the family, for the LGBT community. And I can talk also about the Adrian and Clay and their family, that this case, as I said, took years, contributed to an evolution of their own relationship in the family with their parents, etc. So it was an interesting solidarity moment for that family, an interesting development.
I was just going to say, you have to add the fact that they were kind of natural media stars, because Adrian and Clay as a couple are very attractive, they're very funny, they're very open. So it's a journalist's gift to be able to interview them. And then on top of that, you had Adrian's parents. And I have never seen anything like it. Hand Adrian's father a microphone and he speaks from the heart. And that, I think, was very influential. It must have been influential in Romania.
Yeah, and that offered us a safety net in the context of this very hateful campaign of the referendum that happened 2 years afterwards. Because Romanians already knew about the gay family, and they realized that it's not a threat to their families or to the Romanian society, just like the court in Luxembourg is pointing out that this family does not illustrate a threat to EU, to the Romanian society.
So then the case was referred. I'm cautious of time as well, but we have the referral to the Court of Justice, and then it's quite a quick process, you know, from their DAG opinion, this and that, considering, you know, comparing to other cases. You know, as I said, being involved, I know that there are many actors, and then how did it happen that White and Case joined, and why did you decide to join your efforts in litigating this case?
I can talk about why we decided to join. That was rational. How it came about, that was serendipity. It really was quite a remarkable story of an interlocking jigsaw puzzle which really came together very quickly to form a whole. Justina and I were talking about this before, because we have an associate in our DC office who's Romanian, Andrei Popovic, and he met Adrian Coman at a conference, Adrian living in New York. And Adrian and he talked about the situation in Romania, the difficulties there, and Adrian and Andrei, our associate, set up a call with Justina and Romanita to talk about what White and Case might be able to do with Accept in a general sense. How could we give them some pro bono assistance in Romania? Because we're a kind of funny firm that has offices in so many places, people who come from so many different backgrounds, we can cover so many languages. Andrei thought, maybe we can do something. And the call was due to take place, and in the meantime, the European Court had taken this reference and expedited the hearing. So when the call took place, Justina and Romanita were in a state of panic. Can I say that? And so they said to Andrei, we have this hearing coming up. It's a very important case. Yes, we do need some help. And Andrei spoke to, I don't know if he's here in this room, but Patrick Rickerfor, who many of you know, is the pro bono manager. Andrei spoke to Patrick. Patrick has a knowledge of the pockets of expertise in our firm like almost no one other person. And Patrick called me up and he said, I think we need judicial profiling for the European Court of Justice. You can do that, can't you? Because you're based in Brussels. And I said, sure, I can do that. Tell me about the case. And I'm sitting at my desk. And the wonderful thing about being an EU lawyer is that EU law and the court cases particularly are all in a good database. So I call up Curia and I look and I see, yeah, there's this reference finally, because I get the names. And I said, Patrick, this is a full court hearing and it's coming up in about 6 weeks, less. And he said, yes, that's right, that's the problem. It was actually a month to more or less to the day, because it was just after PILnet actually last year. And so I said, this may be something where they need perhaps more than just some judicial profiling. Do you think I could speak to the lawyers who are concerned? Because I saw the matter, I saw the full court. That's a signal to everyone, this is an important matter. And I saw what it related to, and I thought, well, this is really important in terms of EU law development. So I then had a call with Justina and Romanita. We talked about what needed to be done for the case. We did some initial brainstorming on how the oral arguments needed to be prepared, what the focus should be of that. How did we deal with the different languages? How were we going to be able to handle the likely questions that were going to come? Because there was about 4 or 5 member states intervening. And they said, well, basically, any help that could be given would be welcomed. And I said, I will go and see what I can do. I'll put together a team, and we will do whatever we can. And the other thing that was very serendipitous was I looked at my diary and I saw that the hearing date, I think, was the 21st of November. And I had that was a Tuesday, the Monday, the Sunday, the Saturday were all free. And so I remember as we moved forward in the case saying, okay, we'll set up camp in Luxembourg, we'll meet there on Sunday, we'll work all day Monday. We'll really be prepared for this case on the Tuesday, because we need to have that time together. There is no substitute. But in the run-up, in the month before that, We were in contact, I think, every day. It was something where we realized that this was a kind of short, sharp shock if we were going to manage with you to get the arguments put forward in the way that they needed to be. And it was our great privilege to be able to work with you and Romanita. It was really something where we took it on because we knew that this was a case which had real impact.
And I think what we really appreciated from the collaboration with White and Case and with Jackie's team in particular was the fact that they were so much willing to respond to our needs, to the needs at the local level. No matter what we could think of, they wanted to address that and to help us with that. And while at the same time respecting that we are capable, that we managed to bring this case, and that we have expertise in the areas that we work. And that was really, really valuable for us, and it continues even after the case. And the respect is really, really important because we had other collaborations, and we could compare that.
As someone that was present at the hearing, I can say that all the efforts that you put in, it was just amazing. The pleadings that you had prepared, and the question, answer, everything. It ran so smoothly. It was, I don't know, it was very impressive. So
it was a lot of work to get there.
Yes,
and it was one of the great pleasures of my life to sit there beside Justina. And I was unable to plead in any way because the case was in Romanian, but I realized so quickly that I could kind of sit there and pass you the odd note, but you were just in control. But I also knew that we were all very confident that we'd had the opportunity to really master the way that we wanted to put this case forward. And it was, I think, a real challenge to work through how would this case be won, and how would we tailor the legal arguments to the judges and to the way to get the response and get the result that we wanted, but at the same time draft the pleadings in a way that we also could pick up arguments which were going to be useful for the media. And I think we managed that pretty well.
So there was the judgment on the 5th of June, and we were all very nervously waiting for this, refreshing the website, on the 5th of June, and there it was, the judgment. We personally at ILGA Europe, we had a celebration. I straight away went and bought a couple of bottles of champagne and a cake, and we did celebrate because it was, of course, it was about Adrian and Clay and the Romanian context, but it was for all EU member states. It's now effective in all EU member states, so it was big, huge success. So the judgment, you had the judgment. When you read it, was it what you were looking for?
We were waiting the result with the journalists at a press conference, and we had Adrian's family with us, and we were satisfied with the judgment, despite the fact that, of course, it is tailored to the facts of the case, which refer to the residence permit in the context of freedom of movement. But the way we managed to present the case to the media, the opportunity and the leverage that we got from having a judgment of the Court of Justice of the European Union was the important, the objective that we were after. And also, then the case came back to the Constitutional Court of Romania. They issued their judgment in September this year, and that basically brought the Romanian jurisprudence at the level of European Court of Human Rights standards and the EU law with respect to freedom of movement, and also with respect to the positive obligation of the state to adopt some form of legal protection for same-sex families. the parliament and also the judiciary, who should ensure the protection of the right to private and family life of LGBT people, which was the first time for the Romanian court, and also establishing the level of protection of the judiciary in Romania. So,
yeah, I mean, the celebration that I remember was at the European Parliament when we were all together.
Yes.
And there was a wonderful birthday cake, or it wasn't a birthday cake, it was a celebration cake. And we all talked about the case and the implications of the case, and we were waiting because we were quite convinced that there would be a few parliamentarians in the room who wanted to make some political capital out of what the European Court had done. And in fact, they weren't there. So it was a bit of a damp squib, but it was a good opportunity for us to do some education in Brussels as to what had been achieved as a result of EU law. So that was something which is, I thought, very important. And then for me, the fact that there was so much journalistic interest in the case was noteworthy. And then the fact that it continued, because White and Case was able to work with ILGA to put an amicus brief into the Constitutional Court continuing case. We're not sure how much the Constitutional Court really needed that, but I think it was still a good exercise for us in this continuation of a relationship. And I think that's something which has also come up in the PILnet context. It's not enough for lawyers to kind of leap in, give a memo or maybe some judicial profiles. If you really want to have an effective collaboration, you need to really understand all the different ways in which you can help and stay in touch and then move on to the next stage. And the next stage for us was not exactly representing Accept. It was getting involved for ILGA and others slightly behind the scenes. And then we did another amicus opinion, which was for the case with regard to whether there could be a change in the Constitution. So I personally find the relationship that's been created amongst us all very fulfilling. I think we have been effective in making a difference.
Certainly.
And that's something which I hope will continue.
And I would like to thank you for your continuous support. And yes, Jackie said there was an event organized at the European Parliament in the aftermath of the judgment, and the idea was yes, there was a cake, we continued celebrating, but we had people present from the Commission who are responsible for implementation of the judgment and EU law. And it was crucial to have your presence, and especially your presence, because we relied on the expertise of White and Case and Jackie's expertise in EU law, in addition to support our arguments as well, that look, Commission, now you have the judgment and you have to follow up. And it was very nice. Jackie had a very nice speech as well to kind of say, well, there is no other way for getting out of this. The Commission now has to follow up and the implementation.
Maybe it's worth just sketching in for everyone. I mean, what happened was that we were relying on a provision of the treaty which establishes free movement of persons. This is not new law. This has been there since the treaty was drafted in 1957. So all the court had to do, we said, was apply the law. It was pretty obvious. Now, of course, it wasn't quite as obvious as that, but there was a directive which gave a bit more flesh to the treaty principle. And the directive, which is the Free Movement Directive, said effectively spouses ought to be able to move together freely throughout the EU. But the catch was that there was no definition of spouse. And when the directive was drafted, this was realized. People are not stupid. But it was considered to be pretty difficult to give a definition of spouse that was going to keep, or that was going to get adopted as a legislative matter. And so the Commission kind of backed out. The European Parliament said it should be same-sex spouse in there. And the compromise was, let's just leave it to the judges one day. And it took, 14 years to get to the judges. And so the judges did give a definition to spouse. They said it should be same-sex spouse. And to that extent, the judgment is exactly what we wanted. The judgment did a little bit more in that the court also gave a ruling which said that Romania was not free to invoke the notion of public policy in order to restrict free movement rights, and that there's some EU law control over what's meant by public policy as a justification. That's really important, and that's something we can found on in the future. And then lastly, I would say the judgment was what we wanted, in that the court was not elliptical. The European Court has to produce a judgment which is a single judgment, a consensus judgment. And as you can imagine, when you have, in this case, 15 judges all providing their input into a consensus judgment, sometimes European Court judgments are less clear than one might wish. This judgment is super clear. It cannot be misunderstood. And the press release that goes with it is even more clear. And the court did give specific reference, did make specific reference to European Court of Human Rights jurisprudence, and two cases particularly, which I think is also a very key aspect that we can found on in the future.
Mm-hmm. I'd just like to follow up on this implementation aspect. I'm aware of cases in other countries, in other jurisdictions, in Lithuania, in Bulgaria, for example. There was a case in Bulgaria that actually had a hearing. The first hearing scheduled was on the 5th of June, and the judgment, common judgment, came out in the mornings, and the lawyer took this judgment to the hearing in the afternoon and said, but look, there is a judgment, so the judge applied, and we thought, wow, this is amazing, it works straight away. But now there has been an appeal. The authorities have appealed. Do they have a chance of winning?
No, they don't have a chance of winning, because that's the wonderful thing about using EU law. It is directly applicable. Once you have that judgment from the European Court, which says clearly, this is what the law is, this is what the law is EU-wide. You don't have to wait till the legislation is adopted to change the law. No. If there's contrary national legislation, that should be disregarded. EU law has supremacy, and the law is clear. So your appeal, it should fail.
It should fail. We have a bit less than 10 minutes left before the end, and I would like, to open the floor for questions, please. In the very back, gentleman, Toby, there was another hand raised. And yes, thank you. Let's start from the back.
Thank you. This is very interesting judgment, actually. And I'm from Georgia. I'm Nicholas Legashvili from Article 42 of the Constitution. This is Georgian NGO. Recently, actually, Georgian Parliament received the new constitution, which will be enforced in several months. And there is a definition absolutely opposing to this definition, which is actually we are talking about now. I'm curious about Georgia is trying to be a member of the EU. We are not member of EU yet, but there is an association agreement which obliges Georgia to close to the EU regulations. And could you be so kind to talk about a bit how it could influence on Georgian reality, if you can do this, of course.
I think you've picked up a very, very good point, but I would throw it back to Justina, because remember she talked about how Romania had been using EU law principles prior to Romania joining the EU. So maybe you would like to give some guidance on what you think should be done.
before the accession to the European Union, we had to implement the EU acquis communautaire, which in respect to our issues, LGBT rights, would apply mainly with respect to the area of employment, equality on the ground of sexual orientation in employment, and the freedom of movement would also apply in case of accession. And from that point of view, if Georgia is considering acceding to the European Union, they would have to comply with these provisions. But so far as they are only an associated country to the European Union, that provision, freedom of movement, that is only for EU citizens, is probably not imposed by the EU in the association agreement between Georgia and EU. So from that point of view, the efforts that the state or the civil society is maybe pleading with the government for a future accession to the EU, in that context you can bring this jurisprudence from the court. Otherwise, in terms of relationship as an association country, that is limited from this point of view.
But I think that in reality, if Georgia is moving towards a form of membership or a closer relationship with the EU, you will find that a lot of the discussion will be focused on whether Georgia is accepting EU values. A fundamental value in the EU is non-discrimination on the grounds of sexual orientation. You have the Charter of Fundamental Rights that embodies that. It's Article 21. And so, in a general sense, Georgia will be asked, is this something that you can espouse? So that will be part of the discussions. But in the particularly narrow question as to whether Georgia would have to change its law for the celebration of marriage, that's not something that the EU has competence for.
Can I just add very briefly, as a civil society, you could raise these questions to be included in the discussions. It will be a long process, but if you keep putting it back on the agenda, it would be useful for the push and development. Toby, please.
Hi. Congratulations for such a wonderful case. And it really is a textbook case of good practice strategic litigation. You know, it involves social change through law, it involves community engagement, it involves innovative partnerships. But what I wanted to focus on was sort of innovative legal forums, and using the CJEU as a forum for strategic litigation is relatively new. Where the risk is, and you identified it, is the sort of the threshold to start playing. But if you can get in and you get a successful judgment, it can be a slam dunk. You know, you're all through the way, as opposed to going through the convention system where you can get to sort of political horse trading at the Committee of Ministers level. My question is how you manage that risk. Because effectively you're putting it in the judge's hands to refer. You have little power to do so. Is it presenting arguments where it is just unavoidable to refer to the CJEU? But how did you go about this? It is. There's a gamble there.
Yeah. We used the circumstances that we were in. The fact that some of them were against us. The Constitutional Court was not ready to decide in our favor or to take a decision. That was a good sign for us that they are not ready to decide against us, but also not ready to decide in our favor, because Romanian society is not that open, has discriminatory attitudes, and the Constitutional Court is a quasi judicial and political body. The decisions that they take are political. So we use that circumstance in putting pressure on the public pressure, media pressure on the Constitutional Court every step at a time. So we use the power of the media to present the story in a correct way, and also the fact that judges at the Constitutional Court were not ready. and that they could use this case as a first case where they asked for a dialogue with the Court of Justice of European Union. And it was a clear case of EU law for them and the way we presented it. So that was the opportunity to ask for the guidance of the EU court.
But it's true that it was the first case that was referred by the Constitutional Court to the European Court of Justice. And it's also true that it can be very difficult to get a reference. You can get a reference from a court early in the procedure. You can ask for it, and the court does not have to wait until it has exhausted domestic remedies before a reference is made. But in some countries, and I come from one of those countries, and that country has made its decision to leave, apparently, that's one of the problems, because it's quite a political issue. But if you can get a reference early on where the law is clearly unclear, then it doesn't have to be terribly expensive, and it can take a long time. That is one problem. In this case, very interestingly, the hearing was expedited, and so that was where the problems came up. But you can also get the European Commission to take on cases. If you know that your law is incompatible with EU law, then you can make a complaint to the European Commission. And you can say to the Commission, you can have 2 paragraphs saying, you know, here's who I am, here's why there's a problem legally, and here's the problem, the result of that problem factually. And the Commission may well pick that up and pursue it. That may be also something difficult to persuade the Commission to do. It all depends on whether you hit a sweet spot.
Thanks.
Thank you, Jay. Thanks, Justina. There are 2 more questions, and we have 1 minute left. But if everybody is okay, we'll stay a few extra minutes.
Going back to the same question, have you tried to convince any court, any lower level court, to refer the case to the European Court?
We were prepared to address the request for referral at lower courts as well, but but we were at the same time flexible, despite the fact that we prepared the case as being an EU law case, with hopefully a judge at the lower court referring the case. The government kept on bringing the provision from the civil code that was clearly for us unconstitutional. So we said we were in the process. We decided to go to the Constitutional Court, despite that meant step aside from the initial strategy. And I think it was a good decision because we managed to give more importance to the case, and the fact that the Constitutional Court was willing to refer the case to the court in Luxembourg was maybe something that we should have expected more than a lower court judge referring the case to Luxembourg. In the same time, we argued before the Constitutional Court because there was this question from judges: are we a court of last resort? Because courts of last resort higher courts are mandated to send a referral to the Court of Justice of European Union where the law is not clear, the EU law is not clear. And we argued in front of the Constitutional Court that from the point of view of the issue of constitutionality that is being addressed, yes, you are the highest court and there is no other court to decide on this. So I think that also convinced them, or was an argument in favor of referring the case. And from judges at the Constitutional Court, unofficial information, or we know that the judges who had been reluctant in the beginning of sending this case further in dialogue with other judges, constitutional court judges from other countries, at conference like this one, they realized the importance of the decision that they took, and that is they are being well reflected by taking this decision, and this also helped at getting a good decision in the end from the Constitutional Court, besides having a judgment from the court in Luxembourg.
I'd just like to mention briefly, we made a submission to the Constitutional Court in 2016 when the case was referred to the Constitutional Court on all the EU points, and realizing, as Justina says, that there is this momentum that possibly the Constitutional Court may decide to make the referral. We also, in our submission, made a point about this, that you actually ought to make the referral if you cannot satisfy all these requirements, and this is an EU law case, so I don't know, maybe in tiny little bit it also helps, but yeah, convincing. One last question.
Okay, I will try to speak up. First of all, thank you very much for this great presentation, and congratulations to all of you. Congratulations to Romanita as well. I'm Alexandra Columban from Atedo, Romania as well, so I'm quite familiar with the case. And I would first like to comment and sort of reflect what Justina was saying, that the case was monumental in Romania. It was extremely important for LGBT communities throughout the country, and I think it galvanized, in a way, a sense of community overall and increased solidarity. I've been seeing this in the past years. We're doing like pride marches in another city, in my city, in Romania, and I think the case definitely had an impact. New NGOs as well. So I feel that it makes public space a bit safer for LGBT people. So that was one thing. I would also say it contributed probably to the failure of the referendum in a way, because it failed. It did not reach the quorum, so the threshold. And that is definitely great news. So I would like to ask Justina, how optimistic are you for the future, and how do you plan on maybe capitalizing on the case in order for us to reach full equality and protection for same-sex couples? And I'm particularly referring to civil partnerships.
Yeah, we have a draft law that has been signed by 43 members of the parliament. It was introduced 2 weeks ago in the parliament. It's the fourth draft law that has been introduced, but this time with larger political support. And the arguments from these judgments will help. And what we're also trying to do is to bring signatures from law firms working in Romania to bring them in front of the commissions of the parliament, who will review this law, saying that the bill does fulfill the European standards in the field of the right to family. And if any of the law firms that are here and have representatives in Romania would want to sign such a document, that would be really, really helpful to manage to pass this law.
Good luck with the initiative. We're fully supporting as well. Afraid we have to close the session. Thank you all very much for being here. Once again, congratulations to both of you for the success, and let's hope for more achievements. Yes.
Onwards and upwards.